So, good morning, everyone, distinguished guests, participants, ladies and gentlemen, and of course our students. On behalf of the School of Law of Ukraine, Cyprus, and the EU Enforce project, of which at the School of Law of Ukraine, Cyprus are proud partners, it is a real pleasure for me to welcome you all this morning to this expert webinar, whose purpose is to provide us with an insight on succession and private international law. So this webinar is only one of a series of sessions that are given as part of our own private international law modules. And it is obviously open to academics, professionals, and students for CPD purposes. I would like to thank our colleague, Professor Lombardi, for his support in the organization of this webinar, as well as our guest speaker, Professor Martino. So now I would like to say a few words about the accomplishments of Professor Martino, who has gotten his law degree at the University of Bologna and holds two PhD degrees, one from University of Rome and one from University of Bologna. He is an associate professor at the University of Bologna. Why change it if it works? And has also held a lot of positions in other universities, such as the University of Oslo, where he has conducted academic research. And in Germany, I think I would be unable to pronounce that, as well as the Max Planck. Yes, the Max Planck. In Munster, if I'm not mistaken. Yes, and in Max Planck Institute in Hamburg. He's also a lawyer that has been admitted to the Bar Association and in the Court of Appeal of Bologna, and is also the Deputy Director of the School for Legal Professions in Enrico Redenti, a member of the Bank of Italy Committee for Financial and Bank Arbitration. So his research includes contract law, laws of obligations, securities, and inheritance law, and also a member of the Associazione Civilista Italiani of the European Law Institute and of the Society of European Contract Law. I hope I have not missed anything. So I would now like to give you the floor, and for any questions, I would like to invite our guests to use the chat box, and we can have perhaps a short session, Q&A session at the last 10 minutes or so. Thank you very much.
Awesome. Thank you very much, dear colleagues, students. Thank you very much for having me here today. I am delighted with the idea of lecturing for you, and I'm also very thankful towards my dear friend and colleague, Professor Lombardi, for inviting me here. And obviously, thank you to Professor Stephanie Lollet-Chelou of the University of Central Lancashire for giving me this opportunity. I am a private lawyer. I usually deal with substantial private law, and I know that today the guest lecture series is about private international law, but being also a professional lawyer, I had many times the opportunity to address cross-border succession issues, and my academic field of research is also succession law. So I believe that maybe I have something to say. I hope so, at least. And that's the reason why my intention is to more or less split this lecture into two sections. The first one is a general perspective and a general approach to succession law from a comparative point of view, a legal comparison about succession law, whether if it is feasible and whether if it is also useful. And I am going to rely mainly on a very well-known and authoritative paper by Marius de Waal that you may also find easily in the Oxford Handbook for Comparative Law, edited by Professor Zimmermann, also one of the masters that I had the pleasure to work with in Hamburg, and he is working a lot on succession law nowadays. So more or less the structure of my lecture for the first part relies on the topics that are addressed in that paper, and I encourage you to hit the book and to give it a look, because it is very well written and it is very clear, I believe, in order to pave the way towards a common discourse and a common analysis of succession law in a comparative law perspective. And comparative law obviously has a lot to do with international private law, because we all know, I believe, the very famous sentence by Zweigert and Kurtz saying that these two are disciplines that are sisters. They are sisters disciplines because they, especially comparative law, gives scholars and also legislators the opportunity to find common paths, blueprints, models, and trends also that give the main idea and the main concepts that may solve problem of cross-border succession, given that we are discussing succession law today, obviously not contract law or property law. But succession law is also a realm of private law when we may find intertwined a lot of disciplines that are obviously related one to each other. Property law, family law, contract laws. Think about it, the inheritance contracts that I'm going to speak about in a few minutes also. So when we discuss succession law from a comparative point of view, we need to be aware that there are a lot of intersections and lot of disciplines that we have to deal with, even just scratching the surface, but we have to be aware of the wake, and we have to gauge the importance of these disciplines. So more or less, this is the first part of my lecture, as I was saying. The second part, I'm going to discuss the EU regulation, the well-known, I believe, EU regulation of 2012, 650, because that is a very good exempt, I believe, of how to try to solve problems in cross-border successions. And there are a lot of issues that we may discuss just reading the regulation. There are problems related with applicable law, with jurisdiction, with renvoi, so with cross-reference between different applicable laws, problems with public orders, and so on. But just to start now with the first part of my lecture, I believe that we all have a sort of a static image of what succession is. Succession is one of the probably less capable of modification realms of private law, because succession law is extremely technical. Is extremely technical, and it involves dogmatics probably more than other realms of private law. So common social and economic changes, they obviously have an impact on the law of succession, but it's an impact that we may perceive in a long course of time. It is difficult to observe a legislator that is capable of changing the entire system of succession law in order to comply to these changes, social and economic changes, easily, because it's a very technical system, and every time you touch just a little rule, then everything changes, and probably the system doesn't work properly anymore. So dealing with also international private law and cross-border succession may be a problem, because you have the need to analyze different jurisdictions, different systems, and you have to discuss these jurisdictions and these systems with scholars or lawyers that are from another country and that have another system in their mind, a completely different system that is incapable to adapt itself easily to economic changes and to the needs that maybe in another jurisdictions have already been conceived as possible reason for changing the succession law. Now, it's useful, I believe, to focus on the primary function of the law of succession, that it is an economic function, undoubtedly. It's the problem of if we need a succession law. Using the Latin word, is the problem of an, not the problem of quomodo. If, not how. We need a succession law, we need succession, we need inheritance, because upon the death of a man, of a person, then there's a problem with the lack of a holder for his property. And so we need that his property has a new holder, and that we have a continuous juridical relationships between the decedents, heirs, and the third parties that had a relation with the decedents. That's paramount to understand that this economic function is everywhere when we discuss succession law. And even though we may perceive that there is another very important function that we may define a social function, the maintenance of the family, the maintenance of the spouse, the maintenance of the child, the first problem, the problem of ensuring continuity in property, is always there, and we have to take care of that as the first problem, the first issue in succession law. Obviously, we also have a problem of how to regulate a succession, and here comes the main distinction that is between testate and interstate succession. I believe that you all already know. Testate succession means that the descendants made an act of will, and so the direction of such a continuity in property is the direction given by the descendants himself. And that's very important, because this has to do with freedom, and freedom to testate is one of the most important areas of private autonomy. We all know how much private autonomy is important in the realm of contract law, but in succession law it has an increasing importance. And there's not only the acts of will to be addressed as a means in order to give such a freedom a concrete expression, but there are also the so-called will substitutes that I'm going to analyze in a few minutes. Will substitutes are a bunch of legal transactions, a bunch of contracts, unilateral acts that may obtain the same result of an act of will, but that are devoid of one requisite of the act of will that may be a too strong limitation for the freedom for private autonomy. The possibility until the last moment of the life of a person, of one person's life, to change the act of will, and so to change completely the direction for the property upon the death of such a person. And that may be a problem of certainty in the juridical relations. And the problem of inheritance contracts is obviously that problem. Inheritance contracts are contracts through which you try to fix in not the price, but the property has to be after the death of one of the parties. And so it's very important that the contract is a contract and it's not an act of will. In Italy, for instance, there's a very harsh struggle against the Article 458 in our Civil Code, 458, providing for the nullity of inheritance contracts. Nowadays, we still have such a norm, providing for the voidness of a contract on the succession. But we are discussing about the possibility to change such an article and introduce something that is close to the Hefvertrag, the contract, the inheritance contract that we may find in the German jurisdiction. And this has to do, obviously, again, with the quomodo, with how we want that a succession law may work. And with this premise, I believe it's clear that discussing for a possible harmonization of succession law is very difficult, because harmonization may be not only successful, but also desirable only whether it is feasible. And if we have so many differences in the how side of the succession, how it has to work, then maybe legal comparison may be just a sterile attempt at describing piecemeal rules, piecemeal disciplines, and it resolves in a so-called micro comparison. You just take care of very analytical and technical issues, but you lose more or less the broader approach, and you don't understand anymore whether it is feasible and desirable to harmonize succession law, and then maybe also repeal differences that are there in the different given jurisdictions, and that are the offshoot of their history, of their tradition, and of their culture also. That's another problem for harmonization and comparative and the comparative method in succession law. It's that succession law is a very indigenous branch of law, a domestic probably branch of law, and it's very difficult sometimes to identify general patterns and general trends that may be the basis and the grounds for an harmonization, not an unification, just an harmonization. Now, there are also different views on this side of the issue that I'm discussing. Because there are scholars, Zimmerman is one of them, that are trying to unveil the existence of a common path and of a common legal tradition also in the field of succession law. So it's more or less the same attempt that had been made with regards to contract law and to property law. And there is also an exempt, very interesting historical evidence of the feasibility of an harmonization or of a unification, and that's the creation of Book 5 in the BGB, in the German Civil Code, because that part of the Civil Code was able to harmonize at least 4 different succession regimes prevailing in different parts of Germany at the time. The Jus Commune, the Saxon common law, the Prussian Allgemeinen Landrechts, and the French law. So it is possible, probably. But in order to do that, you need a strong legislature. You need a legislator that is capable of pursuing such an attempt easily and fast, I believe. And on the contrary, if you are in a context like the European Union, where you don't have a legislator capable of jettison all the different jurisdictions and all the different solutions, then you have to work on another path. And this other path is international private law. So harmonization through finding common rules for the applicable law and for the jurisdiction that is enjoying the power to decide on a cross-border succession. But obviously, this does not lead to repealing the national substantial jurisdictions and the national substantial rules on succession law. And this is a problem, because we are going to discuss in a few minutes also that sometimes, even though you have clearly solved the problem of applicable law, then you have a lot of problems with managing the contents of the rules applicable. For instance, just think about the situation where it is not clear whether in the succession you have a property right in rem according to the given jurisdiction. And this is interesting because the EU regulation attempt to solve this problem, claiming for a sort of an adaptation to the closest right that maybe the decedent had in mind choosing the applicable law. But obviously, this is not an easy solution because property rights as well as succession law are mostly and chiefly the indigenous component, the indigenous realm of private law in any jurisdiction. We take care and we are probably jealous of our solutions when it comes to property rights and to succession law. It is easier to find a common path and a common rationale when discussing contract law, remedies, changed circumstances, frustration of contract, and so on. But when you have to discuss whether a given right in property, such as usufructus, is the same as yours, and then maybe I have to repeal mine in favor of yours, that's difficult to accept, and scholars start to feel uncomfortable. So it's not easy to harmonize, even though we are trying to do that through international private law. Now, another very important element that I'd like to stress is that, as I said, the law of succession also entails many rules that have to do with family law. It's easy to understand why. The family as a social unit is first and foremost the easiest default means in order to solve the problem of an optimal allocation of wealth upon one's death. You don't have an act of will, no problem. You have the family relations, and so the easiest way is that the property passes on in favor of the members of the family. Obviously, this solution, it is easy to be conceived from an abstract point of view, but it also envisages a lot of problems when you have to deal with cross-border successions, because family law is, again, a realm of private law where culture and tradition has a lot to do with the solution you may adopt and that you may like also. That's the reason why when it comes to interstate succession, and so when it comes to deciding who is the heir, or when it comes to forced heirship, so when it comes to deciding whether an act of will may be limited for his effects due to the fact that it doesn't take into account properly an essential position, a necessary position of an heir, then the progressive redefinition of family relations may be a problem. And we are discussing a lot also in Italy. Good morning, Ettore. I'm really happy to see you now. I believe that, hi, Ettore. I believe that is aware as I am that when discussing forced heirship in Italy, it's always, you always have an end on your sword, and because it's going to be a struggle with other scholars. Some of us, they believe that forced heirship should be completely repealed because it is an acceptable limitation to the freedom to the state. Some of us believe that forced heirship, it is important because it converts private property at death to family property. And then there is a matter of protecting the family, protecting the members of the family. And maybe it is also a constitutional rule that imposes and forces the legislature to keep forced heirship as an institution. Now, just I take a short rest for my voice because I believe that Ettore wants to give his regards to the attendance, and if you want to step in, Ettore, please.
Marco, just to apologize because I was a little bit late for a problem with the connection, and I know that Maria introduced you properly, and I thank you, Maria, for that. Hi, Maria. Hi to all the attendants. Well, I'm listening to your lecture since the beginning, so it's very interesting. I have a few comments that I will reserve to the end of the lecture that you have. So thank you very much. It's very interesting as usual, Marco.
Thank you very much, Ettore. Thank you very much. So that said, social function of the inheritance law, the succession law, and family law is another matter of interest, I believe. And it has to do, as I said, with interstate succession and forced heirship. But we cannot forget, as I was saying at the outset of my lecture, that the economic function of the succession law is the core function, is the core reason for succession law. And it has to do both with interstate succession, because interstate succession gives us the default rules for ensuring the continuity of property, but it also has to do with private autonomy and freedom to the state. And the role of freedom to the state is undoubtedly increasing in every jurisdiction. When it comes to private autonomy and the act of will, again, we have problems because there are the so-called will substitutes. And will substitutes, as I was saying, they are a bunch of instruments passing wealth outside the traditional structure and rules pertaining to the law of succession. You are obtaining the same goal without adopting the instrument of the act of will as an instrument, with its limitations. And when it comes to deciding whether these will substitutes that are promissory notes, mortgage, securities, deposit agreements, gifts, deeds of gift, pension and retirement plans, foundations, inter vivos trusts, and so on. When deciding about the feasibility and the validity of these instruments as opposite to the kingdom of the act of will, it comes again a problem of dogmatics and of traditions. In Italy, we are not so comfortable accepting the idea that there may be an act that is not an act of will, but that provides for the same legal consequence of an act of will, but devoid of the limitations of the act of will or of the freedom of the act of will, because the act of will, as I said, is a matter of extreme freedom. You may change your act of will until the end. On the contrary, if you enter into a contract with another party, obviously you may withdraw from the contract only if you have provided for a rule allowing you to withdraw. Otherwise, the contract stays there, obviously. So dogmatics and traditions, they have a giant and a very sometimes gross, I believe, role in deciding whether we may adopt these so-called will substitutes. But will substitutes, they are important because sometimes the act of will is not enough in order to realize properly the goal that the future descendant has in mind. Okay, sometimes you want to not provide for an heir, but you want to disinherit someone. And according to the Italian law, for instance, this was a solution challenged by many scholars that were that thought that it was impossible to disinherit someone. Then, fortunately, also our courts started to change their mind and believe that disinheritance is possible. And then also we are discussing for the boundaries of trust and fiduciary trust-like institutions that may be envisaged by an act of will. But again, if you just think that there are will substitutes, and this will substitutes encompasses also trust-like fiduciary institutions, then you have no need to find for compatibility between the act of will and trust. Again, there are many discussions and many struggles about the possibility to frame an act of will as a trust, basically, where the heir or the legatee is a trustee for someone else. Because we have a rule, a mandatory rule, that provides and prohibits the fideikommisso. The fideikommisso is a Roman-based institution that provides that the property passes on towards a person, but only for the reason that that person has to take care for someone else's interest, and then he has to pass on the property again towards this second person. And so, given that we have a prohibition for such an institution, obviously accepting the idea of a trust-like fiduciary heirship is very difficult. And again, the EU regulation that we are going to discuss in the second part of my lecture clearly says that it has nothing to do with trusts. And that's a problem, because in cross-border succession, many times we have to deal with a paramount distinction between common law and civil law that has to do with how the transfer of property works upon one's death. It is not direct, but indirect through an executor, sort of an agent that has to deal with the property and provide for the real heir for managing the property in order to give the heir just the outcome maybe of the property. And in Italy and in continental jurisdiction, on the contrary, we like the idea that the transfer ownership is immediate and direct to the heir, or at least it needs an acceptance from the heir but then the heir is the new holder of the ownership, is the new holder of the property rights. And this may be a problem, because if you have more than one heir, then you have a common, a shared property, and you have to to provide for a sharing out from the property. And unless all the heirs agree on how to exit from this common heirship, then you have to manage and to decide everything about the property, the common property, together. And that would be not feasible, or sometimes feasible but undesirable from an economic point of view. Just think about the majority shares of a company. If the shares go to a trustee, it is obviously, I believe, a better solution than giving just minority shares to be divided among the heirs. Because unless they are capable of dividing the shares at the outset of the succession, they are going to encounter many problems, and maybe the company itself is going to encounter many problems, because you don't have a single entitled person to decide about the future of the company. You have a lot of heirs, and they have to discuss together almost everything about the company. That's just an example, but I believe it's a very interesting example, also because in Italy we tried to solve such a problem, introducing a new institution that is maybe we can call that patto di famiglia, contract among the family members, in order to solve this problem, the destination of property, of shares, or the destination of the company, the main company of the future descendant. But you need the agreement of all the members, also the members of the family that have a right maybe to claim against the gifts, and so they have a right according to the forced heirship rules. And obviously, when you give the possibility to someone to enjoy his right, and then you believe that through an agreement he's going to waive to his right, it's a pipe dream, in my opinion. And that's the reason why patto di famiglia, the contract of this contract among the family members, has not been so successful, I believe. Now, that said, we can go towards private international law and the role of private international law in pursuing the harmonization that I was telling you about. That is a very difficult aim, as I have tried to explain briefly. There has been many attempts through treaties and conventions at building a common path and solutions according to the private international law of the different states, with identifying more or less the rules on applicable law. And there was also a treaty, the Treaty of Washington, 1973, about the so-called international will, but I believe it's a treaty that wasn't able to obtain a consistent and material goal. For instance, in Italy, we have the possibility to enjoy the use of international will, but it is just a possibility. And I believe very few people decide to execute a will with the formalities provided by the Treaty of Washington, because our formalities for the will, they are so detailed that usually a person in Italy chooses the holograph as a formality for the will, or the notarization or the public act in front of the notary. So it wasn't a success, such a treaty. On the contrary, there are at least 3 conventions, Hague Conventions, that we may discuss together briefly. The 1989 Hague Convention on the law applicable to succession to the estates of deceased persons, that allows a testator to choose either the law of the latter's nationality or habitual residence at the time of the making of the will to govern the succession to his or her estate. And this means that the testator's plan of succession will be unaffected even if he or she subsequently changes nationality or habitual residence. I'm stressing this sentence because it is important also in view of the EU regulation. If you allow a testator to choose the law at the time of the making of the will, it's very different from the other possible solution of allowing the testator to choose, or just saying that the applicable law is the one at the moment of death, because it may change, obviously. And that's the solution that we may find adopted by the EU regulation for the applicable law as a default rule, even though you don't have the choice from the testator, sorry. Then there's another, but this convention, 1989 convention, I believe it was adopted only by the Netherlands, and so again, it's not a successful convention. On the contrary, it may be a successful convention, the very well-known 1985 Hague Convention on the law applicable to trusts and on their recognition. Because trusts, as I said, they have a lot to do with cross-border successions, and they have a lot to do with managing the main problem of succession law, if and how we have to manage the lack of a holder for the property. But again, the EU regulation, we're going to see, doesn't take into account trust law as a matter of interest to be disciplined in order to obtain the goal envisaged by the regulation itself. It's outside the regulation, the trust law. Again, it has not been a success, the 1973 Hague Convention concerning the international administration of the estates of deceased persons. It has only been ratified by a small number of countries. And such a situation that a small number of countries usually ratify this convention, again, is the proof, I believe, of the fact that succession law is something that scholars and legislators are jealous of. The succession law has a lot to do with the tradition of a given jurisdiction. And whenever you try to change something, also piecemeal regulation in succession law, you always fear of the problems that may occur in another branch of the succession, the given succession law. And so we are always aware of the risk of changing succession law. And that's, I believe, the reason also why it's not easy that the states ratify conventions concerning the administration of the estates or the applicable law. But for what we may be concerned of discussing the European private law, an ambitious instrument aimed at addressing the complexities that I have tried to discuss with you of cross-border succession is I believe, absolutely the European Union Succession Regulation, number 650 of 2012. It is applicable to the succession of persons who die on or after 17 August 2017. So now it may be a matter of interest because it starts to be actually and concretely applicable law also in Italy. And the regulation has been described as providing a comprehensive treatment of the diverse private international law issues concerning succession, encompassing within the same instruments at least 4 issues: rules on jurisdiction, rules on the applicable law, rules on the recognition and enforcement of decisions and authentic instruments in succession heirs, legatees, and administrators, and also executors of deceased estates, improving their status and exercising their rights in the various EU countries. Is the European Certificate of Succession that has been introduced by the European Union Succession Regulation. It's a very interesting means for proving your quality and your status of heir or administrator. And so it solves many problems. It solves many problems, but again, there are issues in how the regulation provides for the identification of the authority that is entitled to release this certificate. But I'm going to discuss that in a few minutes. That said, I'm trying also to discuss now the EU regulation, starting with an example that I believe may be useful in order to perceive the problem of cross-border succession. Let's think about the case of a US national who is a resident in Los Angeles or in New York, another city in the United States, and who owns a real estate property or a bank account in Germany. And then we have a German court that has jurisdiction over the entirety of the estate because of the EU regulation. And because of the EU regulation, according to a general rule or a subsidiary rule that we find in the regulation, in the EU regulation, and it has to do, the general rule, with the habitual residence, and the subsidiary rule with just the fact that there are property estates in one of the member states for which the regulation is applicable. Now, this problem clearly depicts, in my opinion, that you may have at least 3 elements to be taken into account when discussing a cross-border succession: the nationality, the habitual residence, and the site where the property estates and the movables especially concretely are. Now, why these 3 elements are so important when they are combined? Because obviously the nationality provides for a set of rules and a set of elements, I believe, that may affect the decision of the testator, for instance, to choose the applicable law and the national applicable law in spite of another applicable law, maybe the law where he is habitual residence, of the state where he has an habitual residence, and maybe prefers his national law for reasons that have to do with the formalities needed for the act of will, or that have to do with the protection that the family may enjoy if the national law is applicable. The testator has in mind clearly his rules, his national rules for forced heirship, for instance. And the EU regulation takes that into account, because in the premises there is an article 38 that I'm going to read with you that takes into account this perspective of considering the forced heirship rules according to the national rules when choosing the applicable law. So nationality has a lot to do. Habitual residence has a lot to do with cross-border succession, because it is the conflict rule that has been chosen by the EU regulation as the main rule to be adopted. The conflict rule is that of habitual residence, but the habitual residence is also a problem, because you have to assess the habitual residence, and it is not easy to understand what an habitual residence may be according to the member state whose applicable law we are dealing with. And then the third element that I was telling you, and it's very important, is where the property estates are. Why it is so important? Because there is another main distinction, main possible categorization of the law of succession in different jurisdictions, according to the fact that you may have a principle of unity of the succession, or sort of a splitting jurisdictions applicable, taking into account the fact that maybe you may be a national, let me say, an English person who has property estates in Italy. Now, if the applicable law is the Italian law, the principle is the unity of the succession. And so there's no problem. You apply the Italian laws, the Italian succession law, without having to take into account the fact that the property estates are in Italy or are elsewhere. But if the applicable law is the Italian law, and if the private international law in Italy says that the applicable law is the English law, then you may have a split solution, because you may have the English law applicable to the succession, with the exception of the Italian law that is applicable to only that branch of the succession that has to do with the estates, because the estates are in Italy. And that's a problem. That's a problem that the EU regulation doesn't address properly, I believe, because it frames a general principle. It says many times that the succession is regulated as a whole, but then there is not clear solution for the cross-reference applicable law due to the renvoi, to the cross-reference to another applicable law, national applicable law, that has to be conceived as an applicable law as a whole. So even with the international private law of that state. And if that international private law claims for a different state rule according to the estates, for instance, then you have again a split solution for the applicable law. But I'm going to discuss with you these problems reading the EU regulation, because I believe it would be easier. So now I'm going to share with you the text of the EU regulation, and we may read together a bunch of articles that I believe clearly show how my attempt of giving you a portrait of what the succession law may be as a problem in general clearly is the way that we have to address succession law. So just give me a second so that I may share the PDF. I believe you see that now.
Yeah, we see that.
Okay, thank you, Ettore. Now, first of all, I'd like to read with you 4 articles in the premises where it is clearly said that the EU regulation doesn't apply, should not apply to certain given areas of civil law other than succession that, on the contrary, have a lot to do with succession law, as I hope I was able to describe. Number 11, this regulation should not apply to areas of civil law other than succession. For reasons of clarity, a number of questions which could be seen as having a link with matters of succession should be explicitly excluded from the scope of this regulation. And following, accordingly, this regulation should not apply to questions relating to matrimonial property regimes, including marriage settlements as known in some legal systems, to the extent that such settlements do not deal with succession matters, and property regimes of relationships deemed to have comparable effects to marriage. As Ettore obviously know, in Italy, every time we have a problem with the succession of a couple, then there is, the first issue you have to deal with, a problem of assessing the matrimonial property regime in order to understand whether maybe you have only a half of the property to be addressed by the succession law rules, and then the other half goes with the matrimonial property regime, because you have a sharing out of the common property between the spouses. Then number 13, questions relating to the creation, administration, and dissolution of trusts should also be excluded from the scope of this regulation. And as I said, this is almost funny, because the only convention of Hague that was probably a success, the convention 1985 convention of Hague about trust and recognition of trust, is not taken into account, at least for its possible offshoots, when discussing EU regulation for succession law. And at number 14, property rights, interests, and assets created or transferred otherwise than by succession, for instance, by way of gifts, should also be excluded from the scope of this regulation. But as I said, the main interest nowadays in discussing succession law, taking into account the relevance of freedom and the relevance of private autonomy, is the role of gifts and the role of the will substitutes in a succession. And on the contrary, the EU regulation doesn't take into account this realm of the succession problem. If we may say that there is a succession problem as a whole. However, it is said here in the article number 14, it should be the law specified by this regulation as the law applicable to the succession, which determines whether gifts or other forms of dispositions inter vivos giving rise to a right in rem prior to death should be restored or accounted for the purposes of determining the shares of the beneficiaries in accordance with the law applicable to the succession. And that's because obviously gifts, they have to do with forced heirship. And there is an article devoted to managing forced heirship in this EU regulation that I'm going to discuss with you. Now, following these premises, we may read the article number 1 that is devoted at identifying the scopes of the EU regulation. It's very interesting, in my opinion, because again, it clearly gives us a portrait of what a succession to the estates of deceased persons really are, despite the fact that we just choose to regulate just a little branch or a partial branch of the whole problem. Scope of this regulation. This regulation should apply to succession to the estates of deceased persons. It shall not apply to revenue, customs, or administrative matters. And the following shall be excluded again from the scope of this regulation: the status of natural persons, the legal capacity of natural persons, questions relating to the disappearance, absence, or presumed death of a natural person. And that's okay. But then we have questions relating to matrimonial property regimes and property regimes of relationships deemed by the law applicable to such relationships to have comparable effects to marriage. Maintenance obligations other than those arising by reason of death. And also in Italy, we have a bunch of provisions in our civil code that solve the problem of maintenance obligations for the former spouse after the divorce, and they are envisaged by the part of our civil code devoted to succession law, not family law. But then there's also property rights, interest, and assets created or transferred otherwise than by succession. And again, it's the problem that I was discussing before, and the problem of will substitutes, more or less, and the problems of the creation, administration, and dissolution of trusts, and the nature of rights in rem. Now, I'm jumping to another article now, that is Article 31 in the EU regulation, because it is connected to this exclusion from the scope of the regulation in a very interesting way. Article 31 says that there is the need for an adaptation of rights in rem. Why such a need? Because, as I said, the purpose of the regulation is providing succession rules that are going to regulate the succession as a whole. So as soon as you identify the applicable law needs to be the applicable law to the succession as a whole. But given that the applicable law entails also the private international law of the given state that we identified as the state that has the law applicable, then there may be a problem of split regulation due to the fact that maybe that state provides for different applicable laws to the rights in rem and for the estates for immovables, for instance. And so there may be a problem of adaptation. And where a person invokes a right in rem to which he is entitled under the law applicable to the succession, and the law of the member state in which the right is invoked does not know the right in rem in question, that right shall, if necessary and to the extent possible, be adapted to the closest equivalent right in rem under the law of that state, taking into account the aims and the interests pursued by the specific right in rem and the effects attached to it. It's a pretty difficult operational. It's a pretty difficult task to be pursued, in my view. I don't know how it would be possible to adapt a right in rem when the cross-border succession requires that maybe the applicable law is the applicable law of a common law state, and that applicable law claims for the application of a continental law, for instance, the Italian law, to the immovables for the real estate. And then you have to adapt maybe the right of dispose on the house she was living in with a husband. That is not clear for these Italian scholars themselves what that right should be described as, and you have to adapt such a right to concepts and taxonomies coming from a common law perspective. So this article is very interesting, but in my opinion, is very difficult to be applied. And that's maybe the reason why the problem of the unity of succession and the problem of cross-reference to an applicable law that entails private international private law rules claiming for the application of a third state, the law of a third state should be harmonized better, in my opinion. But that said, we may go back to the general provisions for the first problem that we have when discussing private international law and cross-border succession. That's the problem of assessing the jurisdiction. And after assessing the jurisdiction, obviously, we have the problem of the applicable law. Now, here we may find a set of rules for a general solution of the problem of jurisdiction, and then a subsidiary rule that has to do with the example that I was making at the outset of the example of the US national that has a succession decided by a German court because of the fact that the EU national with his habitual residence in the US has an estate in Germany. Article 4 of the EU regulation provides for a general solution for jurisdiction, and it says that the courts of the member state in which the deceased had his habitual residence at the time of death shall have jurisdiction to rule on the succession as a whole. And here you find for the first time the sentence "as a whole" used in the EU regulation provisions, but as I said, we are going to encounter such a sentence many times. But the general rule is, I believe, very clear. You have to assess the habitual residence, and if the habitual residence is in a member state, then the member state enjoys jurisdiction, enjoys the power to decide upon the succession. But here, the jurisdiction takes obviously into account the moment of death. It is the habitual residence at the time of death that has to be taken into account. Then you also have another rule. There's the choice of court agreement that may be applicable in case the parties concerned in a trial about the succession agree that a court or the courts of that member state had to have exclusive jurisdiction to rule on any succession matter. And such a choice of court agreement should be expressed in writing, dated, and signed by the parties concerned. So it is needed a strong formality in order to perform an exception to the general jurisdiction rule envisaged by Article 4. The other rule that I was mentioning is the subsidiary jurisdiction, and that's Article 10. This is the article applicable to the example of the US national with an estate in Germany. It says that where the habitual residence of the deceased at the time of death is not located in a member state, then the courts of a member state in which assets of the estate are located shall nevertheless have jurisdiction to rule on the succession as a whole, again, insofar as the deceased had the nationality of that member state at the time of death. And that's not the case of the US national that I was mentioning. Or failing that, and here it comes the rule, the deceased had his previous habitual residence in that member state, provided that at the time the court is seized, a period of not more than 5 years has elapsed since the habitual residence change. And where no court in a member state has jurisdiction, pursuant to paragraph 1, whether it is subparagraph A or subparagraph B, the courts of the member state in which assets of the estate are located shall nevertheless have jurisdiction to rule on those assets. And here you find, again, the problem of a split regulation of the succession according to the presence of estates located in a member state, even though the entirety of the EU regulation tries to solve the problem of split regulation, adopting the principle of unity of succession and regulation of the succession as a whole. But here you find, just assessing the jurisdiction, that you cannot escape from this problem, because this problem has to do with the fact that in a succession, in a cross-border succession, the issues that you may have with governing property have to take into account the fact that property may be composed by different elements, and it is of paramount importance to assess whether in these elements you may find assets that have a premise, assets that are located as immovable in a given state. It's the lex rei site that still prevails in framing these rules. Now, this is the first problem I was saying that we have to address, jurisdiction, but then it comes to the most interesting issue, I believe, that is applicable law. In framing and setting out setting down, the applicable law, the EU regulation clearly says that the principle is that of universal application. Any law specified by this regulation shall be applied whether or not it is the law of a member state. And it's interesting because in the following articles, you don't find anymore cited the state with the adjective member state, because it is not as important as well as we are discussing the jurisdiction to assess whether the state is a member state. Obviously, the problem with jurisdiction is a problem of jurisdiction of the member states, because the member states are the member states for which the regulation is applicable. So you have a court in one of the member states that is discussing and deciding on the succession, on the estates envisaged by the succession. But then when it comes to the applicable law, it's not anymore a problem of a member state applicable law. It's a problem of the applicable law, whether the applicable law is that one of a member state or one of a state that is not a member state. Okay, and that's the universal application mentioned by the Article 20. Article 21 provides for the general rule, unless otherwise provided for in this regulation. The law applicable to the succession as a whole shall be the law of the state in which the deceased has had his habitual residence, again at the time of death. Two things we should notice. We shall notice. The first one, again, we find the sentence as a whole. The law applicable to the succession as a whole. That's the main goal for the EU regulation. But as I said, the problem here is that we may have a renvoi, we may have a cross-reference to the law of a state where the international private law rules provide for a positive conflict of laws unsolved, or a negative conflict of laws. Think about the fact that maybe you have a renvoi back. It claims that the applicable law is again the applicable law of a third state, and the article 34 provides for the solution, a possible solution for this problem, because it says that the application of the law of any third state specified by this regulation shall mean the application of the rules of law in force in that state, including its rules of private international law, insofar as those rules make a renvoi to the law of a member state. So it is possible, a cross-reference, insofar it is a renvoi to the law of a member state, or to the law of another third state, not a member state, a third state, which would apply its own law. But no renvoi shall apply with respect to the laws referred to in Article 21, Chapter 2, 22, and other articles. But let's go back to these two articles, Articles 21, Chapter 2, and Article 22. Why such an exclusion? This is very interesting to discuss, because Article 21, Chapter 2 says that where by way of exception it is clear from all the circumstances of the case that at the time of death, again, the deceased was manifestly more closely connected with a state other than the state whose law would be applicable under paragraph 1, then the law applicable to the succession shall be the law of that other state. That is to say that Chapter 2 of Article 21 is able to completely repeal the general rule, because of the fact that you have a manifestly more close connection with another state. And so there is no reason that due to this more close connection with another state, you apply the renvoi, you apply the cross-reference, and you go to the applicable law of a third state, different to the state from the state with which you have such a close connection. It would be completely illogical to adopt the renvoi in such a case. So it's perfectly logical, the exception, in my opinion. The other exception for the renvoi, so you cannot apply the renvoi to a third state, is the case of Article 22, choice of law. A person may choose as the law to govern his succession as a whole the law of the state whose nationality he possesses at the time of making the choice or at the time of death. Two things. First one, it is again logical that you stay consistent with the choice and you do not accept as applicable law a different applicable law, different from the one that has been chosen by the person, because it would be illogical. You are not giving a person to choose the law to govern his succession and then you apply the private international law of that state and change completely the applicable substantial law. So it's clear that to me that this exception, I go back again to the exception, is completely logical. Non-renvoi shall apply with respect to the laws referred to in Article 22. It's okay. But the second thing I'd like to underline is that here you find mentioned not only the nationality possessed at the time of death, but also at the time of making the choice. For the first time, in the general rule, is the habitual residence at the time of death, or it is the more closely connected state, again, at the time of death. Here you find another principle, at the time of making the choice. And again, it's logical, and it is the same principle that we find also in Article 27 and 28. I jumped to these articles. Sorry for the fast jumping, but Article 27 says that a disposition of property upon death sorry, it's not article, it's Article 24, not 27. Also 27 has the same principle, but let's start with Article 24. A disposition of property upon death other than an agreement as to succession, so an act of will, should be governed as regards its admissibility and substantive validity by the law which, under this regulation, would have been applicable to the succession of the person who made the disposition if he had died on the day on which the disposition was made. So again, we are finding the applicable law not at the moment of death, but at the moment when the person made his choice. And the same rule, you find it for agreements as to succession, inheritance contracts, because it is said that an agreement as to succession regarding the succession of one person shall be governed as regards, again, its admissibility, substantial validity, and its binding effects between the parties, including the condition for its dissolution, by the law which, under this regulation, would have been applicable to the succession of that person if he had died on the day on which the agreement was concluded. So, agreements as to succession, disposition of property upon death other than agreements as to succession, and Article 27 I was mentioning, formal validity of dispositions of property upon death made in writing. They are all framed, this is the provision, at the time when the disposition was made or the agreement concluded. They are all framed according to the same principle that we have here in the choice of law. The nationality that he possesses at the time of making the choice or at the time of death. And why this solution is here in the choice of law related with the nationality? Because here you find it written that is the state whose nationality he possesses at the time of making the choice or at the time of death. We have to jump again to the premises, and Article 38 clearly says that this regulation should enable citizens to organize their succession in advance by choosing the law applicable to their succession, and that choice should be limited to the law of a state of their nationality. Why? In order to ensure a connection between the deceased and the law chosen, and to avoid the law being chosen with the intention of frustrating the legitimate expectations of persons entitled to a reserved share. Here you find clearly depicted the connection that I was talking about at the outset of my lecture between family law and succession law, and the connection between forced heirship, family maintenance, and family expectations and succession law. Now, as I said, as I described to you, the EU regulation doesn't deal with directly with the problem of intertwinings between family law and succession law, for instance, marriage, property, and succession law, but it takes into account clearly that there is an intertwining between the nationality, between family law and family maintenance and family perspectives that also the testator may have in mind when choosing the applicable law, in order to frustrate the legitimate expectations of persons entitled to a reserved share. And so their solution is being consistent with the national law that is applicable not only to the testator but also to the persons that have a legitimate expectation. So it's sort of giving juridical relevance to the family relevance again of the succession, and to the expectations that in a succession may the family members have towards also claiming back or recoup gifts and will substitutes that are outside the limitations given in that jurisdiction for the disposable share of the property. So I believe it's very interesting to put into relation this article in the preliminary provisions and the rule providing for the possibility to choose a law, an applicable law, but limiting such a decision to the national law of the testator or of the future deceased. I believe I have just a few minutes remaining for the lecture, and so for this reason, I believe that maybe we may just discuss briefly of the certificate of succession, the European certificate of succession, that we find regulated in Article 62, if I remember properly, in the EU regulation. The Article 62 says that this regulation creates a European certificate of succession, hereinafter referred to as the certificate, which shall be issued for use in another member state and shall produce the effects listed in Article 69. Now, it's important, first of all, to focus on the purpose of the certificate. The certificate is for use by heirs, legatees having direct rights in the succession, and executors of wills or administrators of the estate who in another member state need to invoke their status or to exercise respectively their rights as heirs or legatees and or their powers as executors of wills or administrators of the estates. It's a practical problem that in cross-border succession you encounter every time. Just think about the need to go and ask a bank ask to a bank of a foreign state, of a foreign jurisdiction, to give you information about the assets of a deceased person, claiming that you are the heir or that you are the legatee. And the bank, as usual, and me and Professor Lombardi, we know very well this problem, being both members of the Italian Committee for Bank Arbitration and Solution of trials between banks and customers, that this is a topic, this is a material problem, assessing whether the bank has to provide to the assumed heir information about the assets that are in the bank itself. Now, if the bank is outside your country, knowing whether you have the power to claim for such an information is obviously very important. And the purpose of the certificate should be to let you obtain this information easily. But I believe that it's not just describing the purpose of the certificate in general that may be interesting for you, but to read the legal effects that the certificate has. Because again, we find the usual mixture of succession law, property law, contract law, and family law that I have tried to depict many times throughout the lecture. Article 69 says that the certificate shall produce its effects in all member states without any special procedure being required. And it should be presumed to accurately demonstrate elements which have been established under the law applicable to the successor or under any other law applicable to specific elements. The person mentioned in the certificate as the heir, legatee, executor of the will, or administrator of the estate shall be presumed to have, so it's a presumption, shall be presumed to have the status mentioned in the certificate, and so on. It's the same wording that we have found in the description of the purpose. But it's very interesting, chapter 3, any person who acting on the basis of the information certified in a certificate makes payments or passes on property to a person mentioned in the certificate as authorized to accept payment, or property shall be considered to have transacted with a person with authority to accept payment of property, unless he knows that the contents of the certificate are not accurate or is unaware of such an inaccuracy due to gross negligence. Here we find the principle of reliance and of a negligent possible reliance that is obviously not protected. That is a contract law principle. It's a principle that we find usually described, as you find here described in Italy, for the discipline of a contract that is void because of simulazione. Simulazione means that the parties, they show to the thirds the content of a contract according to the legal consequences or the subject matter of the contract, but then they decide between themselves that the contract has another legal consequence, has another legal effect, or the subject matter of the contract is different. And obviously here you have the need to protect the reliance of third parties on what the contract appears to be to them. And here's the same exact rule that we have in our Italian Civil Code to solve this problem, that you may protect the position of the third party if the party doesn't know the reality of the contract, of the content of the contract, or it doesn't negligently related on the contract content, And here you find it clearly depicted for the effects of the certificate. And also Article 4 says that, Article 69, Chapter 4 says that where a person mentioned in the certificate as authorized to dispose of succession property disposes of such property, so transfer of ownership, in favor of another person, that other person shall, if acting on the basis of the information certified in the certificate, be considered to have transacted with a person with authority to dispose of the property concerned. Again, unless he knows that the contents of the certificate are not accurate or is unaware of such inaccuracy due to gross negligence. Again, we find probably the same principle and more or less the same rule in the Italian succession law when we discuss the action that is the heir is entitled to enjoy when he wants to ask for giving back the possession of an asset envisaged in the succession, and that is in the actual possession of a third party without any valid title. And sometimes the third party just entered into a contract of sale with the apparent heir, with an heir that seems to be the heir, but is not. Maybe because the act of will is void. In such a case, again, the solution given by the Italian Civil Code is the same. You take care of the reliance of the third party, and you take care of the fact that unless he knows or unless he is unaware of the invalidity of this title due to gross negligence, he is protected, and the transfer of ownership or the actual possession is protected. Again, it's the same rule that we may find in simulation, in contract simulated. We find it here for the protection of the heir or the protection of the third party that managed to enter into a contract with the heir, even though the heir is not really the heir because the act of will was void or voidable, for instance, maybe due to a vice of consent or whatever. So I think that in 2 hours, and I'm sorry that maybe in order to give you the possibly wider description of succession law, I rushed on some topics or some issues, but I hope that the portrait is clear enough. I hope also that you are not too much tired, as actually I am after 2 hours of lecturing on such a difficult topic. I believe succession law is always a challenging topic, and merging succession law and international private law is again a very challenging topic to be addressed. So thanks again for your attention, and thanks again for giving me the opportunity to be here with you today.
Marco, I thank you very much. Maria, would you like to say something, or shall I give some comment?
I think since I gave the introduction, you should go ahead.
Great. Okay, so Marco, nothing to say more than thank you for the lecture that you gave us. It was very impressive, very interesting. And I kindly disagree with you when you say I was rushing, I was not super clear as I wanted. You were very clear, you were very good in timing, you were full understandable, and I thank you very much. Very, very clear. So it was very important and very nice for me as well for a general update of your thoughts and your ideas according to the orientation of the UE law and the international law. I would like to stress some points, and then I will give the floor to the participants if they want to ask some question. So I would like to stress some point that is summarizing considering some syntagmas. So first of all, you stress the need of harmonization, and you stress as well the economic function of succession. So making reference to the interstates succession and to the function of private autonomy. So these 2 points are very, very important because they are conditioning the UE law tendencies in this field. And what is very, very interesting for me was the address that you made to the fideicommissum institution that we don't use, or rather, we cannot use in Italy. Very important as well for the relationship that you created with the trust that is admitted in Italy. So very important. And what was as well very interesting for me, apart from the very broad but deep consideration of the treaties, the Hague Conventions, and so forth, was the idea of splitting jurisdiction. Very important idea that you stressed because it's a paramount profile that we have to consider. Regarding the fideicommission and this potential substitute to the act of will, I have a question for you, but I would like to give the floor, first of all, to the students, to the participants, if they would like to ask something to Professor Martino, considering the fact that he is still available, and it will be very important to ask something to him, to take this opportunity. So I see some students as well of our course, like Dinos, Temel, Christou. So if there is some question, otherwise let's go ahead, because we cannot keep Professor Martino for longly. No question, Maria, right? Neither in the chat?
No, I cannot see any. There's some thanks from some of the participants.
Okay, great. So, Marco, may I ask you very briefly, yes, more a curiosity or a way to understand your point of view on this field. So, you stressed how the UE law is now operating and acting in a way that can be considered a little bit probably rigid. So as far as I understood, the way to substitute the will are few, and that is a way to, let's say, not give address, gives room to the private autonomy. So the future tendencies of EU law, I'm more considering EU law because we are European, will be toward stressing the private autonomy of the part, and therefore giving more flexibility, as well giving the possibility to have more substitute, as you were saying, to the act of will, or will be more a tendency of a full harmonization as well in this field. So to create a rigid approach that will be against, of course, the private autonomy, but more pro a real harmonization, a real commune discipline regime.
I believe it's a very difficult answer to be given because personally, I believe that a full harmonization, or at least a unification in succession law as well as contract law, is an attempt unfeasible, an unfeasible attempt. For contract law, we assisted to a collapse of the attempts of building a uniform contract law system throughout codes or piecemeal legislation also. And I believe that in succession law, this is also very difficult due to the fact that, okay, we may say, and we all agree that private autonomy is good, private autonomy is very important, and we have to foster the freedom of the testator to adopt will substitutes or to disinherit maybe the member of a family, or to just frame the succession the way he believes is this better. Also because it's the closest person to the property, and so probably is in the best position to decide. But at the same time, when it comes to succession, I believe that we cannot repeal the principles underpinning forced heirship. I'm not one of those scholars believing that forced heirship is something that we have to jettison and to put aside in order to obtain a better European private law environment. And I believe also that the idea itself, in itself, of a European private law that comes from the Ordo Liberalismus is the idea that, okay, you need private law. European law is the European private law society, but that means that you have to take care of the market. You have to take care of the market against the problem of the state that claims to perform strong interventions on the market, and so maybe produce distortions of the market and in solutions that are not desirable for the market. But at the same time, you have to protect the market from private powers. And private powers, they are also a problem of a position of a person may have in a given social environment. And the families, they are given social environments. If I have an heir that has an economic power and has the possibility to produce solutions that are not desirable for other heirs that don't have the same economic powers. For instance, provoking a decision for the future descendants to enter into an act of will where there is the disinheritance of the least economic strong heir. That's not a good solution, in my opinion. That's not a good solution also from the point of view of ensuring and assuring the highest possible freedom to the state and private autonomy. Private autonomy doesn't mean that you may do whatever you want. It's something else. And I believe that in succession law, sometimes we have a pipe dream, sort of a pipe dream, where everything is possible, just leaving the testator take care of his own property. But the testator, when he's in his own room, is closed in his own room, in this silence, and is writing his act of will, then is influenced by so many factors that we have to take them into account, and we have to put limitations. And so I believe that the EU regulation for the substantial succession law, not for the international private law, but for substantial succession law, may be feasible only if we accept the idea that private autonomy is important in succession law, but we cannot repeal also the need for recognizing a social function in succession law, not only the economic function, also the social function that has to do with family, also family that changed a lot because we encountered many changes in families, in models for families, same-sex families, adoptions, families not based on marriages. Okay, but we have to be aware of the fact that all these models have to do with succession law. And I believe that the articles that we have read during the lectures, even when telling us that they did not want to take into account problems of family law, of property law. In some way, they were assessing that there is a problem of intertwining between succession law and family law, because they have to take care of each other. I believe that's my idea, but I believe it's a very abstract idea, probably.
And Marco, thank you very much. And that leads to a major flexibility. So that's probably a major point that we have to consider. Marco, I would like to thank you really, really a lot, because as a master, you are in this field, and not just in this field. You gave us many information, and thank you very much as well on behalf of the School of Law.
Thank you,
Maria.
Thank you for your kindness.
It's true. Maria, a word to you.
Thank you so much. I am sure the students have learned more than they would have just by giving a plain lecture, because you bring in the specialist element, and I'm sure our guests and the practitioners have also learned more about that, especially since we were living in a globalized environment, and we have now many mixed families. So it was really, really nice to hear. Thank you so much. And we have some thank you from the students as well.
Oh. Marco, thank you very, very much.
See you. I hope this is the first occasion for a collaboration between our universities, University of Bologna and the Cyprus University. It would be nice to have another occasion, maybe organized by the alma mater with Ettore and all of you. Okay?
Thank you.
Absolutely. Thank you so much.
Have a nice day. Bye.
See you later. Ciao, Marco.
Ciao. Ciao.